Whenever an FIR is registered, the question that comes to the mind of the accused person is that whether the police is going to come to my place and arrest me, and what remedies do I have? Do I need to apply for anticipatory bail or not? So, anticipatory bail is a kind of bail application that you can move before the court if you anticipate or you predict that the police authorities are going to arrest you. So, it is a kind of protection that you get from the court, wherein the court directs the police authorities not to arrest you on the ground that you will join the investigation, you will cooperate with the police authorities. So, whether anticipatory bail can be applied prior to registration of FIR, the answer is no. Many people think that that they can apply for anticipatory bail even prior to registration of the FIR, but it is maintainable only after the FIR is registered. But whether you should apply for anticipatory bail in your case or not depends on the facts of your case and the sections that have been put against you. In one of our cases, an FIR under 498A got registered against two brothers, and they applied for anticipatory bail, even though there are guidelines laid down by the Supreme Court in numerous judgments that in cases wherein the punishment is of up to 7 years of imprisonment, arrest of the accused persons is not necessary. The police authorities are supposed to serve notice upon the accused person to join investigation, and if the accused person is cooperating with the police authorities, arrest is not required. But still, these two individuals, they applied for anticipatory bail, and surprisingly the anticipatory bail got rejected by the sessions court and even by the high court. So in these circumstances, even the investigating officer had a pressure to arrest these accused persons, because in the opinion of the courts, the accused persons had committed such an offense in which they were not entitled to anticipatory bail. The matter ultimately reached to the Supreme Court, and ultimately the Supreme Court also rejected the anticipatory bail applications, and they had to then surrender before the police authorities. In my opinion, if they would have not applied for anticipatory bail, they would be in a better situation. They would not have gone behind the bars, because there are guidelines by the Supreme Court itself that in 498 and similar matters wherein 7 years of imprisonment is there, anticipatory bail is not required. So, applying for anticipatory bail, you should take proper legal advice from a lawyer who's practicing in criminal law, because the even the conduct of the police authority is different from state to state. In Delhi NCR, the police authorities do not arrest in such cases generally, but in many parts of India, the police authorities are misusing their powers. So it depends where the FIR is registered, what are the allegations, how serious the allegations are. Only then you should think of applying for anticipatory bail, because if you apply for it without taking proper legal guidance, then you might have to suffer.